The Madlanga Commission of Inquiry heard fresh testimony this week that raises direct questions about the independence of the judiciary and the prosecutorial service. A senior former official described repeated attempts by political figures to influence case allocation and the appointment of acting judges in high-profile matters. The evidence given under oath points to patterns of pressure that, if proven, would breach the separation of powers set out in Section 165 of the Constitution. The rule of law rests on the idea that no one, including the executive, can dictate outcomes in court. When testimony suggests that dockets were steered or that acting appointments were used to tilt benches, the damage is not merely reputational. It strikes at the enforceability of court orders and the willingness of ordinary citizens to accept judicial decisions as legitimate. South Africa has seen this erosion before during state capture years. The Commission's task is to establish whether those habits have persisted or been revived. Constitutional lawyers appearing before the panel have stressed that acting judicial appointments must remain temporary and strictly merit-based. Prolonged use of acting judges creates leverage points. A judge hoping for permanent elevation may feel subtle pressure to deliver results pleasing to those who control the appointment process. The testimony presented so far indicates that such leverage was allegedly exercised in at least 2 provinces. If the Commission accepts this evidence, it will have to confront whether the Judicial Service Commission itself requires structural reform to insulate acting appointments from political bargaining. The National Prosecuting Authority faces parallel scrutiny. Witnesses described instances where senior prosecutors were moved off cases after refusing to drop charges against connected individuals. Such moves, if routine, convert the NPA from an independent constitutional body into an instrument that can be redirected by external interests. Section 179 of the Constitution demands that the prosecuting authority exercise its functions without fear, favor, or prejudice. Testimony suggesting otherwise cannot be dismissed as administrative friction. It tests whether the constitutional guarantee still holds in practice. Critics of the Commission argue that some evidence amounts to hearsay or settled political score settling. That caution is fair. Not every allegation of interference will survive cross-examination, and commissions have historically been used to smear opponents. Yet the pattern described across multiple witnesses from different institutions is consistent enough to warrant systematic investigation rather than dismissal. The test for the rule of law is not whether interference occurs in every case, but whether institutions can detect and correct it when it does occur. The Commission's interim report, expected within weeks, will likely recommend legislative changes to tighten acting appointments and strengthen protections for prosecutors who resist external direction. Those recommendations will only carry weight if Parliament treats them as binding rather than optional. Past experience shows that reports can gather dust when they implicate powerful interests. If this one is sidelined, the constitutional message will be clear. Judicial independence is a paper promise, not a lived reality. Public trust in courts is already low. Further erosion through proven political meddling would deepen cynicism about every contested judgment. The Madlanga process therefore carries weight beyond its immediate findings. It will either demonstrate that the constitutional order can police itself or confirm that the levers of justice remain vulnerable to capture. The coming weeks of testimony will decide which outcome prevails.